Kenyans think the judiciary ought to be celebrated? Just Njoki.
Thank you very much, Chair. I think that the thinking during the drafting of the Constitution, that the judiciary was a subject matter, that there was trust deficit around the judiciary because most of the judges, or all the judges, were direct presidential appointees. The judiciary had no budget, and therefore Kenyans were very untrusting or distrusting. I think moving from the promulgation of the Constitution of Kenya 2010, we've seen many changes. We now see far much more decisional independence of judges, where judges fear not that night phone call from State House, as was in the dark days, where now we have seen more operational independence, as gradually the judiciary is getting a little bit more funding, that is increasing staff. We are now increasing judges. The judiciary is now operational in 47 counties, and therefore access to justice, which was partially a vision of the Constitution, is now, we are on the journey there. There's also the issue of Kenyans who now come to the judiciary. And people say that Kenyans are very litigious. They come to court on every matter. I think that it should be celebrated. There was a time before the Constitution of 2010 when not all Kenyans could come to court. There was the issue, what we call formally in the legal language, of locus standi. But now, any Kenyan can come on any issue, and they are doing so. And therefore, I do believe that the Constitution is working, and the judiciary too.
Thank you very much. A round of applause for her, but I'll still be with her. And we said we're going to be transparent. So indeed, there are also those who see some challenges when it comes to the judiciary in terms of overreach of the judiciary. For example, the gentleman next to me, representing the executive, probably will say they are having it difficult to run the executive because of overreach by the judiciary. There are those who would say that the judiciary has independence, it cannot be touched by any outside party, yet the judiciary shields its officers from accountability. What would be the remarks from the Lady Justice? And I understand you are a sitting judge and your remarks will be circumscribed.
I think that the Constitution is very clear in Article 10, where all the national values bind all state officers, those who work in the executive, those who are in parliament and in the judiciary, that we must follow the rule of law, that there must be transparency, accountability, we must allow participation of the people. Therefore, it is the duty of the judiciary to be the guardian of the Constitution and to defend where any arm of government does not follow the Constitution. That cannot be judicial overreach. That can only be fidelity to the Constitution. There are many challenges, of course. We've seen that as we listen to some of the cases. There are a number of tough wars. You know, some of the cases that come before us, some are between Senate and the National Assembly, others are between the national government and the county government. But those are disputes that we do resolve. However, there is a concern that sometimes political questions are brought to the courts, and courts cannot answer political questions. Courts may only answer judicial questions and points of law, and perhaps therefore the political class ought to be encouraged to resolve political disputes outside of the corridors of the courts.
Thank you very much. Let me go on the other side. Senior Counsel, Parliament is the first institution of the Constitution. Much is given by the Constitution to Parliament. It has the power of the purse, it has the power to vet the President's senior appointments, it has the power to make laws, it has the power to summon any and all government organs. Yet, I think I speak for many if I say many Kenyans are not happy with our National Assembly and our Senate. It's starting from the president and the former prime minister all the way to the villages. What is it about parliament that has not endeared itself to the people as far as the powers given to parliament by the new constitution and the powers given by the people to parliament?
Thank you, Session Chair. First, allow me to thank the President for the proclamation. Your Excellency, you will be surprised when you are watching the ceremony for promulgation. I'm sure you did not see the committee of experts anywhere. We were 9 of us, 3 international experts, 6 local experts. Our chair has since passed on, the Honorable Nzamba Kitonga AC, and I'm praying that he might be recognized posthumously. But as soon as we released the final text of the Constitution to the government printer, nobody remembered us. We didn't even have a seat. So it is today that now I have a seat. So I thank you 15 years later. Njoki Ndung'u will tell you, Professor Sempebwa brought his wife all the way from Uganda and could not sit. Secondly, fortunately for us, both yourself and the Prime Minister were in Parliament, and you are there much longer than me. So if there are things to be known, I'm sure you know them. But more fortunately, I'm here with my Speaker, Session Chair. I hold no leadership position in Parliament. So if anybody is to be crucified, please look for the Honorable Wetangula. Me, I'll give my perspective. I will give my perspective from having participated in the Committee of Experts to my experience now in 8 years. First, I am the first to concede, and I've said this and I've conceded it in public, that I don't think we are doing well in Parliament, especially the 13th Parliament. I am not here to apologize. But just like all other branches, there are successes, but there's work to be done. At least in our favor, 15 years down the line, we still have a bicameral Parliament. 15 years down the line, we've held elections regularly. We are still able to vet. We are even able to impeach, as we recently did. So at least it is there. But there are 2 problems that I see. One is historical, and one is institutional. The historical one, Chair, you will remember, is the problem between the National Assembly and the Senate. In the Committee of Experts, we had designated the Senate as the upper house. You who were in Parliament then decided that we did not need a Senate and removed it. When it came to us, given the historical experience that we had in this country, we decided we needed a Senate at least to protect devolution. So unfortunately, all the powers we had given to the Senate were removed, and we left the Senate with a threadbare role of protecting devolution and taking care of the interest of the devolved units. Very little. And ultimately, therefore, with the subsequent interpretation by the Supreme Court and all, there remains sibling rivalry between the Senate and the National Assembly, and sometimes it becomes a problem for Parliament as Parliament. That is historical. The institutional one is one of our creation, and it was created before I joined Parliament. We changed, the Committee of Experts had proposed a parliamentary system. Members of Parliament, in their wisdom in Naivasha, changed it to a presidential system. And so we had to make things to adopt to that presidential system. Whatever we made to adopt to the presidential system does not seem to have been reflected in the structure of politics. So that what we have now is you have members of Parliament from the party that is in the executive, and because they are the majority in Parliament, they call themselves government. You have members of Parliament from the minority who call themselves opposition. Members of Parliament are yet to learn that there is no government or opposition inside of Parliament. There is only the majority and the minority, and collectively we are supposed to oversight the executive.